Hello and welcome to the podcast. I'm Karen Weaver. My guest today is Tim Nevius. Tim is the founder of Nevius Legal, a college athlete advisory firm. Tim will also soon launch Fair Sports, an extension of his work to include arbitration and independent resolution. Tim, welcome to the podcast.
Thank you, Karen. My last name is pronounced Nevius.
Nevius,
Sounds
my apologies. Okay. All
no
right.
no worries.
I appreciate that. Tim, you're a former college baseball player. Did that help enlighten you into what the challenges might be in this world?
Sure. Yeah, it absolutely did. I mean, I would say that even though playing Division One baseball at the University of Dayton has its challenges and its rigor and all of that, it's not, participating as a football player at Ohio State necessarily, or even a lacrosse player at UCLA or wherever the case may be. But similar, and I think almost uniformly true for most college athletes, almost regardless of division or sport, are the requirements and the time demands and the obligations that come with participating in sports at the next level. And so it certainly informed my perspective in that regard and understanding what the athletes face as they go through their college careers.
When did you play college baseball? What period of time?
Late 99 through 2003.
Okay, so not that long ago in the big scheme of things. How much has changed since then for the
Oh,
athletes?
yeah, so much. I mean, a lot has changed with respect to, um, even I mentioned the demands and the requirements, but even those demands and requirements have gotten even greater for the modern college athletes. Whether that is because of the competitiveness of being an athlete, from youth sports through college and beyond, or because of uh, the the demands placed on them by their coaches or their parents or the universities or the expectations and maintaining your roster position, maintaining your scholarship. And then also the rights and benefits obviously have changed significantly, extraordinarily. Starting with, I guess, the from dating back to, I think it was late 2010s when they introduced the miscellaneous expense allowance and
Mm.
beyond, where they started to increase incrementally the elements of a financial aid package to the full cost of attendance after a ban and Alston payments, but as well as the considerations related to health and safety, academics and academic pursuits, the selection of your major, your chosen major, or course of study, and actually getting to graduation as well. Not to mention the job market and everything in the economy after graduation. So a lot has certainly changed.
So you have a lengthy legal career, but you wanted to launch FAIR. Tell us a little bit about what that stands for and what that means and why it's important now.
Sure. Yes. By background, I am a lawyer and primarily a sports lawyer, working formerly at the NCAA and then since then in litigation, including the Alston litigation, and then on behalf of athletes with universities, with brands in the NIL space included. But FAIR is a new venture at FAIR Sports, and FAIR stands for Forum of Arbitration and Independent Resolution. It is essentially a dispute resolution tribunal or forum for resolving disputes that we anticipate coming up in specifically in college sports. And so, and just to simplify it even further, because we in launching this and having discussions, not everyone has a legal background. And so, explaining just what dispute resolution is, it is essentially what we're referring to are the kinds of issues or cases or disputes that would typically go to court.
Hmm.
And that includes things like breaches of contracts or claims for payment or things of that nature that traditionally are going to go before a judge. But the reason that you would want to go before an alternative forum, such as FAIR, is because arbitration or mediation that we also provide is typically much faster, it's much less expensive, it's much more efficient, and it's confidential. And so the issues are not discussed or released publicly. And in our case, it's specific to college sports because of all the unique issues in the space, in the industry, and higher education and otherwise. And we have a set of arbitrators and mediators that know the space inside and out, and therefore are going to be able to address things more efficiently, we think, and with more greater attention and expertise.
So give us an example of what a typical NIL deal might contain, and then where your company might play an important role.
Sure, and that is one of the types of agreements that could result in a dispute is an NIL agreement. Our forum is designed to resolve any type of issue that faces stakeholders in college sports, whether they be universities, athletes, the collectives, agents and agencies, and things of that nature. But the type of agreement you're referring to, NIL, name, image, and likeness, is typically an endorsement agreement that runs between an athlete or someone referred to as talent on the one hand, and a brand or a third party on the other hand. In this instance, I think what we're talking about are the agreements with the universities. So these new agreements that are going to come about, assuming that the House settlement is receives final approval in April, then athletes can strike agreements directly with the universities in exchange for compensation, and they will, in return, provide the university with the use of their name, image, and likeness in a variety of circumstances. They often take the form of most NIL, virtually every NIL agreement has a licensing component, which is essentially just permission to use my right of publicity in the form of my name, image, and likeness to promote your brand, in this case, the university. And then oftentimes it's accompanied by a set of services. Those services may include things that then I have to actually do under the agreement that include, for instance, appearing at events, making appearances, public appearances, speaking engagements, signing autographs, shaking hands with donors and boosters, posting things on social media, actually taking, I have to actually post something that you provide me on my social media. I appear at photo shoots, things of that nature. And so those are the typical components, very
Yeah.
simply put, of endorsement or NIL agreements, but they encompass a wide variety of things to tailor towards whatever the needs of the parties may be.
So typically in the past, when you were an athlete, back when I was an athlete, we'd think of those things as just doing something nice for the institution because we love the place. Why does this need to be codified now?
So I think what you're saying is in terms of what the athlete is doing in promoting the university, perhaps.
Yes, I
Well,
just love the institution and I want to go out and go to the car dealership and wave and shake hands.
yeah, well, I mean, it doesn't necessarily have to be reflected in an agreement, but that's where we are because it has gotten to this point, given the commercial aspects of college sports, the highest levels, the highest conferences in particular, and so the economic pressures have resulted in this, and I guess, inflection point at which college sports is to, share some of the revenues with the athletes. And that's the subject matter of the House settlement. And again, if it receives final approval, it will allow universities for the first time ever, not require them, but allow them to share money compensation directly with the players. Now, it doesn't actually require anything in exchange, but most of the universities are taking the approach that if they're going to compensate the players, that it's going to be in the form of an NIL agreement in which they also receive in return the use of their name, image, and likeness in connection with the promotions that you're talking about. And
Okay.
so there still may be, ways in which the university and the athletes engage in general promotions and, activities under under a release or a grant of rights or things like that. But most of it looks like it's trending towards, if you come play for my university, I will award you with perhaps a scholarship and, on the other hand, a NIL agreement, and you will engage. I will pay you now through revenue share. It's carefully, I have to be careful about saying that because they're making sure that it's not classified as pay for play, but instead I'm able to share revenue with you and I'm able to pay you for NIL licensing and endorsement services. Whether an athlete wants to engage in, there's going to be a negotiation, I guess.
Yeah.
What are the types of promotions? What are the types of activities? What are the services that are required? Is this simply in the spirit of being an athlete at my university and want to promote the, generally post stuff on social media or speak about the benefits of being a student at this school or participating on the sports team? Or, does it require even, more engagement, such as with the donors and the boosters and making appearances, like I mentioned? So the
Yeah.
extent of the services will probably vary.
I think that's what's going to blow some presidents' minds, right? And see other university leaders. Because we just think of this as we're turning out alumni who will then give back to the institution, love us, champion us in their communities, that type of thing. How do I adjust my mindset in this new world as a president?
Hmm. Well, I guess it really is going to vary by institution, I think. There's a lot of conversations happening right now as to, um, how do you engage in intercollegiate athletics consistent with the values of with
Right,
higher education and with
right,
your institution? And I guess the needs and the demands of the people you serve, whether that be um, your individual students, your student body, more narrowly your athletes, your alumni, your fan and your donor base. So I really think it's going to vary across different schools across the country. Um, I think that at the highest level, so the revenue generating sports at the top conferences, they're certainly adjusting as everyone else is, but they, I think, are more familiar with the commercial elements that have been involved in college sports for a number of years. And it's really just taking a new form that they've always tried to attract and recruit the top talent in their respective sports to come and participate for their athletic program, which has its own benefits and opportunities. And now there's a new element involved, which is, traditionally it's been here's a scholarship agreement, financial aid agreement. Here are some other benefits on top of that as a participant of our university. And now here is a revenue share agreement that is an additional amount of compensation we're able to provide you now as a result of the changes in the industry.
Yeah, I think this is really going to be shocking. Maybe not for the Power Four conferences and Notre Dame, but for certainly the other conferences where maybe they're only opting in two or three sports. Maybe they're not opting in their entire program. So how do you help presidents balance out the difference, even within their athletic department, of how some athletes will be treated, receive more money, have more expectations, those kinds of things.
You know, Karen, if I had the answer to that, I don't
Come
know.
on.
I'd be sitting here right now. What I find interesting about this, and I mentioned this in a presentation alongside actually Scott Beerby from the NCAA last fall. It is in the context of this type of question. My response was, there was a report that came out related to the over commercialization of college sports and the emphasis on sports versus academics and concerns with the recruiting
Right.
environment and concerns with highly paid professional coaches. And I said, was anyone familiar with that report? And my point of which was to say it was the Carnegie Foundation report in 1929, which is
Yes.
now 96 years ago.
Yeah.
And so these types of issues that you're talking about have been a part of higher education and intercollegiate athletics since the beginning. And it, continues to evolve, obviously, and maybe the severity of the issues has increased, quite a bit. But the same sort of value judgments are in play, and the same I guess you have to make decisions consistent with what your mission and your values are.
Yeah.
And and that's going to vary by institutional, vary by sport. And I think that to your point about how do you make decisions, when you're talking about the softball team versus the football team
Yeah,
and the lacrosse team versus the bowling team or whatever the case may be, those are really really tough choices for the universities, for the presidents, the athletic departments, the athletes as well. Um, and we'll probably have some bumps in the road along the
yeah.
way, and as we go through this period of adjustment.
So talk to us a little bit about how fair might help in this situation. How first off, knowing that your company exists, and secondly, at what point would you get called in, and who would you get called in by?
Sure. Yeah, those are good questions. I'll start by saying Fair Sports is a public benefit company, which means that it is intended to serve a public benefit, in this case, servicing the needs of college sports stakeholders and resolving disputes. The reason that we started it was because we are anticipating a pretty substantial number of disputes coming up in the near future, particularly as schools engage in these new transactions with athletes that they have never done before, and that is continuing to evolve, and there's some complexity and nuance to it. We've already seen in the last year or so a number of disputes that have been high profile in public, in which athletes have said, I was promised this and I didn't receive it, and
Hmm.
they've sued their university, they've sued their coaches, they have sued the collectives. And just recently, I've been engaged in an athlete agent dispute. These are things that, as the stakes are raised, the number of disputes is virtually inevitable. It is inevitable that there will be disputes. The question is where is the best and most efficient way to resolve those disputes. So if an athlete claims a breach of contract because the coach had promised something that didn't come to fruition, or a university had reflected something in agreement that was also, not received, or vice versa. The university has put a requirement in a contract that the athlete did not fulfill. How do you enforce that provision? And in fact, we've seen that as well recently in the Wisconsin case and the transfer athlete
Yeah.
down to Miami. Um, so FAIR was developed to most efficiently and effectively and fairly resolve those disputes before a neutral, completely independent tribunal made up of sports law experts that have their finger on the pulse of college sports and have excellent experience as litigators, as arbitrators, as mediators, and have the ability to navigate these, the complexity of these issues
Hmm.
and disputes to resolve them in the best interest of all the parties. And where FAIR stands apart is that it is focused exclusively on college sports. So the subject matter expertise is really important. It also gives us the ability to craft rules and procedures that are specifically tailored towards the types of disputes we anticipate in college sports. And we have all of the other benefits that come with neutral arbitration and mediation, I want to emphasize, because it is faster for sure. It is more efficient for that purpose. It is less expensive, and it is confidential. And so you don't have these public cases talking about airing out dirty laundry and all of the consternation that comes with that. Instead, you have a place to quickly and effectively and privately resolve these disputes that we are forecasting to be quite substantial.
Yeah, yeah. So would this relationship be written into every contract with an NIL? Does it, or any revenue share? Is that how it would be figured?
Great question. And yeah, to answer that part of it, it's the question about how does the case get before fair? Typically, in any contract, you will have a provision that is a dispute resolution provision. It essentially says that if there's a breach of this contract or there's a dispute between the parties to this contract, then we agree that we're going to resolve this in front of fair sports, and for neutral arbitration or mediation, for
Okay.
instance. And so, if then a dispute arises, you look to the contract, has a dispute resolution provision, and the parties then are required, if there's a dispute, to bring that case to that chosen tribunal. In
Okay.
this case, fair. And so, this is the timing of this is important because as universities right now are crafting these new agreements with their athletes, these revenue share agreements, and for the first time recently, I saw that even in a scholarship agreement, there was a reference to dispute resolution, which is unique because typically scholarship agreements go through a school specific appeal process within
Right.
the parameters under bylaw 15 of the NCAA rules, depending on division. And so there's new contracts being drafted, and we're encouraging schools to put in their contracts the dispute resolution provision that refers these cases to fair. One of the unique wrinkles now, there's also, if you don't have a dispute resolution provision in a contract or something else comes up, you can refer the dispute through what's called a standard submission agreement, which is essentially, Karen, you and I, we have an agreement, but we don't have a dispute resolution
Mm-hmm.
provision. We say, hey, let's resolve this by going before fair instead of going to court because it doesn't benefit either of us. Court cases take so much time and
Yeah.
they're very expensive. Then let's go ahead and agree in a short paragraph that we're going to submit this case to fair. So that's another way in which cases may come to our attention. What we're trying to do is, we're anticipating there's going to be disputes,
Mm-hmm.
and
Mm-hmm.
we'll have provisions to effectively resolve them. But we also want to try to assist schools in avoiding the escalation of disputes before they get to
Okay.
arbitration. And for state institutions in particular, because there's the concept of sovereign immunity, which is essentially that state institutions don't have to
Yes.
consent to being sued in court, including appearing in an arbitration, then they can include a provision that refers to non-binding mediation. So there's
Okay.
a mediation process that attempts to resolve the issue prior to any litigation. Schools will still have to face litigation if an athlete brings a case and says that even if sovereign immunity is a defense that you bring, you still have to defend against it in court before a judge.
Okay.
And that's not going to be efficient for people either. I think state institutions are realizing that there has to be some mechanism by which they resolve or address these disputes, whether it's through mediation or through arbitration. Um, and we're also creating effectively an ombuds position, which we haven't come up with the name just yet, but it's going to be someone who facilitates a conversation or a negotiation on the front end, more of an informal type mediation before things escalate, so that an athlete or a school can engage in a dialogue before things really escalate. And what
Gotcha.
we've seen, and I've seen in my own practice, is that oftentimes you can avoid these types of escalated or more serious disputes on the front end if you just have really good, effective communication and identifying what's the issue, what are our goals here, both short and long term, and how can we reach some sort of middle ground to avoid escalating things to a wider dispute.
So, average size of a Power Four program, 500 to 1,000 athletes. Every one of them will have to sign a document like this. Is that correct? If,
Well, so they
uh,
certainly don't have to,
okay.
right? This is a choice. There's nothing being imposed upon anybody with respect to arbitration or fair sports.
Okay.
If the parties choose, and we think there's a reason why they should, disputes are inevitable. Where are you going to resolve these disputes? Anticipate it now so you can avoid the heartache and the issues in the future, and put it in your contract. If a dispute arises, if a dispute arises, we will resolve it before arbitration, before fair sports, for instance. But
Okay.
so it's at the party's election if they decide to do it. Now, there are, no, there's probably reasons why parties will do it. We think that it's a sensible solution to a forthcoming problem, and our whole goal is to really reduce the burden on the parties that be, including, the universities, the athletes, and others in the space.
I'm just trying to imagine the administrative issue of trying to get and I just don't know. So I'm asking, 500 to 1,000 athletes. So each has to, in order to get revenue share, they have to sign this, whether it's $50 or $500,000, correct? They have to
Yeah,
sign an agreement, not with the arbitration, but just an agreement.
that's right. That's right.
Okay.
Yeah.
So
And so,
I'm the let's say a swimmer on the women's swim team, and both my parents are attorneys, and they want to read through the contract. And even though I'm only getting $100 from this whole thing, they want to challenge some of these things. How does that work in controlling the ombudsman, if you will, their time, from the start of preseason practice all the way to the end of the year?
it's going to be a lot,
Yeah,
and there's, universities, university presidents, athletic directors, athletic administrators, they already face a lot of these
yeah,
issues, right? They're in tune with issues that athletes face, even if it's not, reflected in a contract, and expressions, from parents about, concerns or issues that they've raised. And so it's not necessarily unfamiliar territory, but there is a new aspect to it. These are legal transactions now that are going to be taking place. In some cases, they're going to be 6 and 7 figure payments. Now all of a sudden, some of the people
yeah.
some of the athletes are going to become some of the highest paid individuals at the university.
Yes,
Now
yeah,
they're not employees. I'll be careful about saying that they're independent contractors for these purposes, but the stakes are heightened, right? And I
yeah,
would I would argue that, and I've seen this in my experience and my practice as well, is that the stakes have been raised every year for the last several years. The value of participating in college sports is higher than ever. The value of maintaining that opportunity, whether it's your scholarship or your roster spot or whatever it is higher than ever. But more directly to your point, if an athlete, and this is how we've calculated it, is that if there's a scholarship agreement on the one hand and a NIL or revenue share agreement on the other hand, and each of the 200 athletes at each of the top 100 schools, which are conservative numbers,
yeah.
but all sign a NIL agreement and a scholarship agreement, and only 1% of those result in a dispute. That's 400 cases every year.
Yeah.
Now, we think that there's probably going to be a subset of cases that are more substantial. Those 6 figure payments, those 7 figure payments that are probably going to, when there is a dispute, probably going to be resolved through a mediation or arbitration process. But there's other agreements, like you referenced, even if it's just $100, or let's say more realistic, let's say it's $5,000, something like that, that is a nice chunk of change, but relative to other, agreements is probably pretty small. That does it make sense for us to spend the money to go before to court? Certainly not. Does it make money to go to arbitration? Probably not there either, unless there's something else involved there. A mediation process might be, if it's a half day mediation, you might be able to resolve that and address what the concerns are. But in the absence of that, or I should say, as an alternative, you have somebody that facilitates a communication between the athlete and the university, or the athlete and the collective, or the collective and the university, whatever the case may be, because you realize it's not efficient for us to try and take this before a tribunal.
Yeah.
We have a person that's going to help facilitate that
Yeah.
informally, to say, your goal is X, and do you want to make it to graduation? Do you want to continue to maintain this relationship with the university? What is it that you want to accomplish? And tell us about what your issue is and what your problem is. Let's try and resolve this. Then we take it to the university, or vice versa. And we say, university, here's the issue that has come up. We think that there's probably a sensible solution here that doesn't result in going before a tribunal, an
Yeah.
arbitrator, a mediator.
Yeah. Yeah.
Can we reach some sort of agreement before things escalate?
Yeah, and you had the transfer portal on top of all this, so an athlete conceivably, if they transfer two or three times, could be signing two or three different contracts, and they could look different from institution to institutions, conference to conference. How does FAIR address that? Are they looking for a similar template, or just an opportunity to negotiate and solve the problem?
So FAIR, to be clear, is an independent, neutral body focused on dispute resolution. And so we don't represent any particular individual. We're simply providing a service that serves the stakeholders in college sports. And so you mentioned multiple agreements. There's, athletes may have overlapping agreements. There may be an athlete
Yeah.
initially signs a 3 or 4 year term, an agreement for a 3 or 4 year term, but then after the first 6 months decides this isn't right for me, or there's something that changes, or the coach departs, or whatever the case may be, and they strike another agreement. Did they violate a provision of the first agreement such that the university has to enforce that? Is there what we've seen some language that effectively serves as almost like a buyout? Something like a
Mm.
clawback or a liquidated damages clause, which is another way of saying that if we've paid you some money and you violate the contract because you went to another school contrary to what your commitment to us was, then you have to repay that money. Or we have a liquidated damages clause that essentially means that the school you're going to is going to have to bail you out, to buy out
Right.
that contract in order for you to continue participating or striking a new agreement. Those things are going to come up. And what I would say, you asked the question, is how do we handle it? Just like we would any other dispute. And I say we, it's our neutral arbitrators, referenced
Mhm.
that they're arbitrators or mediators. They're referenced, the colloquial term is neutral. The neutrals will be in a position where they independently assess the merits of each case, and they issue a determination as to whether the contract was breached, what the award should be, effectively the findings plus the damages or the recourse, depending on the party at fault. We're going to see that stuff. I think we are already seeing it even before full revenue share has come into play. And so I think it's inevitable that we'll see that. And what we're trying to do is efficiently address those disputes and help prevent against to the extent we can, the escalating disputes before they get to a full scale arbitration or litigation.
Understood. And I think presidents would be supportive of that too, because nobody wants their school splashed over the headlines saying, this is what's happening to this athlete, that type of thing. Um, Final question. So I'm a new president. I'm coming into the chair and my school has opted in. I have never been part of this system before. What questions should I be asking of my athletic director to help me help him or her in this process?
Good. Well, again, you come with the light questions here, Karen. This is
My job. It's my job.
it's really it's really challenging. And I think I'll go back to previous responses that include it. It's going to depend on your school. It's going to depend on your institution. And, if I think what you said was, if you're coming in as a university president, you have questions to ask the athletic director. It's, um, what are our priorities and why? Um, you're certainly going to have conversations, I imagine, about um, what what are our revenue projections, and what does that revenue serve? And in most institutions, it's going to be creating opportunities for athletes to engage in intercollegiate athletics. Oftentimes, they're thinking about what is the way that we can best prioritize, certain aspects of the athletic department, or how can we create the most opportunities for athletes to engage in intercollegiate athletics. It's going to vary
Yeah.
by institution, and even within conferences, it will vary by institutions within those conferences.
Yeah.
But really, just coming up with what are our priorities, what are our values, and how do we exist within this changing industry in a way that best accomplishes whatever those goals and those
Right.
priorities are.
That is the $1 million question, I think. That's a great question to end our discussion on. Tim, I am so grateful not only for your unique perspective that you bring as a former D1 athlete working for the NCAA, working on behalf of college athletes over these last years, and now trying to think ahead a little bit for the industry that clearly wants quick resolution on both sides. So it makes a lot of sense. I think you've given presidents a lot to think about. Thank you for joining me. I really appreciate it.
Thanks for having me, Karen. I really appreciate it. It was a great conversation. Reach out anytime.
Thank